Hey guys, welcome to another episode of Darshan Talks. I have with us the famous Rebecca Tushnet. We've had Rebecca with us multiple times. She's always ever popular. My only regret whenever I talk to Rebecca is I feel like a complete dumbass because it's so fun and she's talking like a completely different level. It's super fun. So I love it. Thank you so much for coming on, Rebecca.
Thanks for having me.
But I'm excited because we're going to talk about hopefully two different situations we're dealing with. The first one is about stem cells and the claims you can make in stem cells, but how people are wrong about the claims they think they can make. So I'm going to before we start, Rebecca, if you want to introduce yourself.
Yeah, so I'm Rebecca Tushnet. I teach at Harvard Law School, and my focus is on copyright, trademark, and false advertising. And so I think we usually talk advertising law because it's one of my favorite things, and a lot of medical issues come up.
Absolutely. And Rebecca, you are a blogger who talks about a lot of these things, and stem cells was one of the things that popped up for you. So what happened recently in the stem cell world, and why should we care?
So earlier this year, the FTC in the state of Georgia won a fairly significant case against stem cell clinic promoters, including people who sort of promoted this for a bunch of small practitioners as a revenue adder and sort of provided them with all the marketing materials. And then in late August, we have a guilty plea for actually criminal charges for making unapproved drug claims about stem cells for the treatment of really, as far as I can tell, anything under the sun.
So let's start with the beginning. In the end, the FDA is responsible for for approving claims for safety and efficacy. Why is the FTC even involved here?
Right. So the answer is that the FTC and the FDA have substantially overlapping jurisdiction, and they've basically divided things up so that the FTC handles things that are primarily on the advertising side and things that are, sort of schemes to promote something. Whereas the FDA is focused on manufacturers of drugs, and that's not complete. Obviously the FDA cares some about advertising, but in terms of who focuses most on harm to consumers, that's the FTC, whereas FDA is more interested in harm to patients, so physical harm, not just monetary harm.
That's interesting. I'll add to that a little bit more. In my case, there are departments within the FDA called OPDP, for example, Office of Prescription Drug Promotion, which does get into that. But it's an interesting distinction you drew on patients versus consumers. What do you think is the distinction? Why does it matter? I've never seen that distinction drawn before.
So, I think it's actually just a rough and ready practical distinction, right? So the FTC thinks a lot about how consumers understand messages, right? And so as opposed to, what is a drug's mechanism of action, right? So the FTC is not going to go after things that are sort of really debatable, but that the FDA might come to a conclusion one way or the other on, right? It's going to wait for the FDA for that. The FTC is more in the business of tracking down the snake oil people, right? Which is clearly what's going on with the stem cell situation. So, because from the perspective of truth, this is easy, because they're just making claims that are way outside of what is reasonable.
But see, that's kind of interesting. Who is the they in this situation? Yeah. Because you pointed to two separate theys. The first was the actual stem cell clinics, and the second was the marketers. Does it matter who the they is, or is everyone responsible?
So I would say, everyone is responsible. So the FTC standard is you have to have a reasonable basis to make claims, right? And that what is reasonable varies depending on the circumstances. In certain cases, clinical experience can in fact be a reasonable basis, as opposed to two double-blinded
multi-center,
controlled trials.
controlled, blah blah blah. Yeah.
Right.
So,
so the FTC standard is just much broader and more flexible, and it's designed to handle the factual basis for anything. We just look to what sort of, people in the field would say is good enough substantiation. And in the medical field, that actually overlaps because, most people in the field say, the FDA standards are what reasonable people would require. So in this case, we're just very far off from having, anything like the necessary substantiation. But so if you were claiming, your pomegranate juice was good for people, then you might be in at least in a better position to say to the FTC, the science is complicated, maybe we exaggerated, but, not by much.
But I think it's kind of interesting in this situation that we're talking about. For example, you talked about the competent, reliable scientific evidence standard, the CAR standard. You talked about this reasonable basis, if you will. Couldn't a doctor go, look, by definition, I'm a doctor. I'm allowed to engage in practice where I believe this is good for my patients. I'm allowed to engage in off-label prescribing. How is this so different?
And the answer is it's different because they lacked a reasonable basis, right? So and a clinical basis could, clinical experience could definitely satisfy the FTC's standard, but it's actually notable what the FTC is going after is focused on these companies that provide all these marketing materials and provide the training, right? So what they're doing is they're going to small practices and saying, I have a new revenue stream for you. We'll sell you the stem cells and all the marketing materials, and we'll explain how to overcome consumer resistance, and it will give you sort of this turnkey operation to increase revenue for your practice. And it makes much more sense for the FTC to go after the people who are sort of promoting that. I wouldn't say that the practices are quite victims, but they are
accomplices, if you will, almost.
Yeah. They're less culpable, and also like it makes more sense to go after the people who are actually spreading this like mold across the country than a given practice.
So that's interesting because the FDA would typically go after the practice or go after the manufacturers.
Right, go after the manufacturer, right? Because the FDA in theory, isn't regulating the practice of medicine. That being said, like if it's an unapproved drug, it's an unapproved drug. You're not supposed
to. Now we've got this situation where we're saying that we're going to go after the marketers. Is that an unusual situation? Because usually speaking, again, the FTC, you usually see the claims against the company still. Because in the end, you as the company say yay or nay. You as the company go, my product does not demonstrate that. I should have put a stop to this claim.
Yeah, so I think it's very industry specific, and I think the model where somebody develops something and then tries to sell it to a bunch of small practitioners, that isn't just limited to medical practices. There are lots of businesses, they'll do it for restaurants, right? They'll do it for law firms, for different things, obviously not stem cells. But when that is the model by which something is spreading, the FTC is going to try and go for the source of the infection, essentially.
Now, the source of the infection, so let's say this marketing company had lawyers helping them. Theoretically, could the FTC go, yeah, we're not only going to go after the marketers, but the lawyers who advise them on that type of issue?
So it's a good question. I'm not aware of any FTC actions against lawyers, but there is the standard crime fraud exception, right? If you're helping people break the law, then being a lawyer is not going to protect you. There are actually some false advertising cases against law firms that have succeeded. Recently in the area of timeshare exit. So, sort of far afield from medicine, but it's certainly possible if you're like actively engaged in, helping to get money wrongfully from people, you absolutely could go after the lawyers.
Now, you've got a situation in the case of the FDA, which has lost a bunch of cases, as you know, around off-label promotion. The FDA itself put out what's called the consistent with the label guidance and put out what's called the SIUU guidance, essentially saying, look, maybe we've been a little too cumbersome around sharing off-label information. We're going to allow for certain type of information to be shared. And then you had Loper Bright, which came in, and that's potentially changing what can be said, what can't be said. In light of all of this sort of evolving information around off-label, why is FTC still coming in the way, if you will?
Again, because I think in this case, both the FTC and the state of Georgia were fairly confident that what they were dealing with was, snake oil salesmen, sort of outright people who were preying on the misery of others, right? So if you read the stuff the FTC cited, there are these sheets about how to convince people to use the procedure, and they just had a script that the script said, based on your condition, I am confident that we can give you significant pain relief. We've succeeded with patients like you, but it's a script. Right? They're saying it to whoever shows up. And that's just, frankly, I do occasionally wonder how these people sleep at night.
It's funny because that was one of the things you actually emailed me. You're like, I can't believe these people do this. What I find fascinating, the Department of Justice, and we'll put a link to it in our comments, but the Department of Justice, if you look at the comments on YouTube, you'll see the actual reference. The Department of Justice specifically goes, you guys misled the FDA, and the order stated that the stem cell products were being sold for research purposes only. From my perspective, that's kind of interesting because at a regulatory level, the argument is from a research perspective, there are certain things you can test and try. And I can see a whole bunch of claims saying, number one, this is not for research purposes only because there's no IND filed. You're just making this up as you go along. But that's not under the FTC's jurisdiction. So would the DOJ claim, could it have been brought by the FTC?
So it's a good question. So the FTC, there are criminal violations, but the DOJ handles them. So it would have to have been under, but could you have also added, violation of the FTC Act? Quite possibly, yes.
So you talk about the violation of the FTC Act. The FTC Act is sort of this overarching, addresses like 9,000 things. Could you talk a little bit about the FTC Act? What is the scope of this?
So basically, it is there are some carve-outs, but it's about deceptive and unfair practices in commerce, and there are like some weird and sort of politically driven carve-outs, and banks are regulated separately. Shipyards are regulated separately, right? For weird political exclusions, but air carriers are regulated separately. But otherwise, they basically have jurisdiction over most of the economy.
That's fascinating because for me, when I see something like the FTC Act, I've seen it applied in the context of privacy. I've seen it applied in the context of obviously advertising. I've seen it in versions of antitrust. So you're kind of like, these are just completely unrelated areas of the law. but everyone just goes FTC Act.
Well, so I think the FTC has a theory of the economy, which is that, there are principles that apply no matter what it is that you're selling, right? And so both deceptive and unfair are, very broad. They're flexible terms, and that's because deceptiveness and unfairness might work in different ways, but they have different theories of what actually is unfair. And then, they decide what they'll go after. And unsurprisingly, one of the things they're very interested in is when things are unhealthy, right? So a couple months back, you may have seen the FTC and the FDA issued a joint letter to people, to cannabis companies about selling, gummies that look like candy.
Yeah.
Right?
Yep.
And that's because that's the overlap of their interest. The FTC is coming at it from the deception side. The FDA is coming at it from the cannabis side. But, when both are involved, they'll both show up.
Now, in a situation where now you now have Loper Bright, which says that you have to interpret your regulation in light of the law. Do you foresee a challenge that comes out and says, FTC, you have over-exaggerated the rules and the powers you've been given under the FTC Act? Are you seeing any serious challenges there?
So what I would say is Loper Bright itself is not going to directly affect this, because Loper Bright deals with a situation which the FTC is rarely in, because usually it doesn't make APA rules. So basically, Loper Bright is about what happens when an agency makes a reasonable interpretation of the statute that's not the best interpretation. And the court says no deference to the agency on that. Right. But Loper Bright is itself about statutory interpretation. And Congress can deal with that by saying, okay, for this agency, you should allow them to make, any reasonable interpretation of the statute. That kind of language would suffice to fix Loper Bright. And it's also why, so because the FTC is often making rules under a more stringent standard called Magnuson-Moss, it has to go through more steps, and it gets evaluated differently. Interestingly, in order to make rules, usually the FTC has to show that a practice is widespread before it can make a rule. Even if everybody agrees it's a really bad thing, it still can't make a rule unless there's a widespread problem. So what I would say, though, is Loper Bright is reflective of a larger shift to what Mark Lemley calls the imperial Supreme Court and the imperial judiciary. So the judiciary is going to decide whether you were right, even though they're not experts. So technically, Loper Bright does not affect like the parts of a decision where the FDA says, okay, here's the new drug label, right? Here's what we'll approve. That being said, the orientation of courts today is not to pay attention to agency expertise. So, the court that decided Loper Bright could also be expected to be skeptical of, individual decisions made by an agency. But that's going to be a lot harder, and it's not clear that courts really want to be in the business routinely of identifying, whether a study was good or not.
Right. Which takes us to the Nephron and the Pacira case. And the reason I think it takes us to that is we're shifting from FTC focus, this sort of overarching, you're very clearly wrong here, to a, is there more nuance to this situation? We're talking about compounded drugs. For those people who don't know, compounded drugs are basically when a pharmacist can come in and say, there's a drug on shortage, for example, and we're going to make the same product. And a very famous one right now are all the GLP-1s, which is your weight loss drugs. So it's just not enough of it was being made. a bunch of compounding pharmacies went out and said, we'll make them, made a ton of money on it. The question is, can you make the claims a lot of these compounding pharmacies are making? Because theoretically, the drug companies can't make the claims that these compounding pharmacies can make. And does that raise all kinds of issues? And then there are obviously copyright and trademark issues that pop up, and state law claims that pop up as well. But I'm gonna let you sort of bring it all together. Onto you, Rebecca.
Yeah, so this is an interesting case that was recently a preliminary decision basically refused to dismiss the case. So the maker of the name brand drug sued a compounding pharmacy, and what it said was, first of all, everyone agrees that this drug is not on the shortage list, right? So if it's not on the shortage list, you're supposed to only compound it in response to a prescription from someone who needs it. And there are plenty of scenarios where this is quite sensible. So say you have someone with a rare allergy, right? And they can't take the normal one. You want the compounding pharmacy to be able to compound that for them. And without, running into regulatory trouble. But, to restrain that, they say, you need to be doing it for a specific patient. And the allegations are that they are very much not that they're sort of broadly marketing it and, making way too much for it to be a specific patient oriented. And so that if true, that would violate the FDCA and, potentially subject them to, penalties from the FDA. But there's no private cause of action under the FDA. So what do you do if you're the company who looks and says, hey, this compounding pharmacy is, eating our lunch and it's definitely illegal, but the FDA isn't going to do anything because it's got a bunch of other fish to fry.
Right.
So the answer is you try to frame this as a false advertising case and you say you are falsely advertising that these are legitimate, lawful compounding activities. And, there's an inherent difficulty with that just at the sort of level of proof, which is it's not obvious how many people really care if everything else is true, right? Important if, but, if in fact you're making the compounded drug that you say you are, and it has the, clinical effects that you say it has, do I really care that it's in violation of the compounding rules? Maybe no.
But here's the question: you don't know that it has the same effect, because by definition,
that's true, right? But the theory of a plaintiff in this type of case does not require them to prove, right? So yeah, you could have a different false advertising case and say, actually, it's not clinically the same, right? Fine, right? But that's harder to prove, and of course the burden of proof would be on the brand name manufacturer, and maybe they can prove it, maybe they can't, but what they are really sure they can prove is this isn't on the shortage list, right. And you're making 10,000 units a month, right. And so the falsity part seems very easy to prove. Right, and not necessarily the materiality part, which is the does it matter part of the claim. But you think you maybe can, and so the potential problem with the legal theory is a necessary step in falsity is saying you guys are breaking the law, right? Right. You have, in order to establish falsity, you have to establish that they're breaking the law. Therefore, their claim to be a lawful facility is false.
Right.
Right. So historically, courts have often used a doctrine called the primary jurisdiction doctrine to say, if the falsity claim requires me to, or a fact finder to decide whether you're violating the FDCA, we're going to wait for the FDA to handle that, because, what do we know about this? And, it's very interesting to me. This recent case doesn't mention Loper Bright because it's not implicated by its terms, but it does have that flavor of, I'm not going to wait for the FDA. I'm capable of reading the statute and deciding what's going on. And I'm actually thinking about writing about this because I do think it's fascinating, because the primary jurisdiction doctrine is older than Chevron deference, which is what got destroyed in Loper Bright. And it's this older, idea that, wait for the expert agency that will decide, like, is literally in charge of deciding which facilities are okay.
Right.
But it's not it's sort of, on the one hand, like, there are arguments on both sides. So it is completely reasonable for the FDA as regulator to say, here are 5 problems with the facility, clean them up, right? Were you in violation? Sort of, but we don't want to shut you down over it, right? As long as you're sort of working in good faith. And having a court decide that kind of shortcuts that process. And it just means, you're definitely a lawbreaker. That's it. And that's probably not the best way to regulate. Probably you do want a fair amount of back and forth, especially when the regulatory task is very multivalent, right? There's a whole bunch of stuff going on. And over time, you want the facility to, improve and sort of be a reliable partner. On the other hand, the FDA is extremely overwhelmed, right? There's a lot of stuff it's not going to get to do, even with, even if everyone is working every hour of every day at top performance, there's not enough of them to, regulate everyone. So, why shouldn't someone who is being specifically harmed by a violation of the law get to bring a case and say, hey, stop it?
Right. So what I hear you saying is that a lot of people may not care. Do you think that this will eventually, right now it's being framed as a false advertising case? Mm-hmm. Do you think a better option, if you will, is patients coming in after the fact going, I was physically harmed because I saw your ad, I bought this drug, and I didn't see the benefits I expected?
Right. It's a really good question. And what I would say is that I think the problem with that from an outsider point of view, because I don't do, general tort law or malpractice, is that there's this sort of welter of confusing laws and preemption arguments, right? Making it very hard to hold anyone responsible for a bad drug, in any given case. So, it's not impossible, certainly, but I would say, there aren't really standard paths to it, right?
Interesting. Okay. Now, do you think that a physician's office that prescribes a medication should, so that learned intermediary doctrine that we've always learned about in law school, does that doctrine apply to reviewing and auditing the claims being made by these compounding pharmacies to make sure that they are appropriate?
Right. And so the learned intermediary doctrine basically says, even if you give, not great information, right, the doctor is the one in charge. And so it's the doctor's responsibility to review and identify if it's not great. And so it's very hard to make the claim as the patient against the manufacturer, because you had to get past them, the doctor, to get the medicine. So so basically blame the gatekeeper. It's never struck me as a particularly good idea, right? Especially since, just like lawyers, most doctors are not really good statisticians, nor, do they need to be for most of the things that they are doing, right? And so when the manipulation is happening at the level of statistics, which it often is, it's very hard for a doctor to detect that unless they have special training and interest in statistical analysis. So anyway, it's not a great doctrine to begin with, but I think the one of the reasons that we disfavor compounding is precisely to try and channel, right? Precisely because there are few private constraints on what the drug is, labeled for, and what. So we worry about having a lot of different manufacturers. Right. So compounding is kind of dangerous precisely because of all these other things, or I should say risky rather than because all these other things are set up to make compounding a sort of niche area.
But it is a niche area. Doctors are prescribing it. Patients are benefiting from it. Do you think that if a patient does not benefit from it, they can go to the doctor and go, you should have looked into it. You had a duty to make sure that I'm protected from these products. And
yeah, right. And that would just be you shouldn't have prescribed the compounded version. So it's certainly a perfectly valid theory, right? It's just, it's going to face the usual barriers to a malpractice claim.
Right. Do you foresee, so the obvious four types of claims we could make, and we kind of explored each one of them, from manufacturers, from the physicians, if you will, from the patients. Is there any other possible cause of action that you see in this type of scenario, and from the original manufacturers, but any other causes of action, and how do they sort of play out?
Yeah. No, I think that's so the only other real possibility I would say is people who pay insurance claims, right? And you do see that occasionally, right? Occasionally. So, like the state of Hawaii suing somebody for, for jacking up the prices, or for, falsely advertising a particular drug as particularly useful to Asian, Asian patients.
It's interesting. In my practice, I'm seeing fewer and fewer individuals coming out and saying that we want to be paid. They'll basically come out and say, I don't want third-party payments. It's an all cash type of scenario. So you're seeing fewer of those. It's not completely eliminated. I just thought that was interesting because of exactly what you're pointing out to. I could keep going, but I have taken up more time than I usually do, and I appreciate you as always. Any parting words, Rebecca?
No. Congratulations to Shogun for doing so well at the Emmys. How about that?
I didn't see the Emmys. What was it? Have you been watching it?
I know. I just read about it, but Shogun's really good. It's my recommendation.
There you go. Thank you, Rebecca. This was amazing as always.
All right. Thank you.